Hello and welcome everyone to this lecture of Company Law. I am Santosh Balika and I'm very excited to begin a brand new lecture series on company law, starting right from the basics. And this will be helpful for all the CA, CS, CMA student and any law student who is trying to build a strong legal foundation in the subject of company law. Before getting into the definition of company under the Companies Act, let us first understand what does a company basically mean. Company is basically an association of persons who come together and they bring capital for the purpose of doing an business activity. Okay? From such business activity, they are expecting some profits to be generated, and such profits will then be distributed to such persons in proportion of their capital. Okay, the same concept is explained by Lord Justice Lindley. And what does he say? Lord Justice Lindley says that company is an association of many persons. Company is an association of many persons who contribute money or money is worth to a common stock and employ it in some trade or business, and who share the profit and loss arising therefrom. Okay, the same concept that we just discussed over here, association of persons. Okay, they bring in capital in the form of common stock of the company. Okay, for the purpose of doing any business or trade, and any profit which is generated out of it. So they will be sharing that profit, who share the profit and loss arising therefrom. Okay, so this is given by Lord Justice Lindley. Clear? So the common stock so contributed is denoted in money and is the capital of the company. Okay. So the contribution which is made by every person, which is used by the company for the business, is known as the capital of the company. Okay. And such persons who are contributing to the company are called as the members, of the company. Okay, members of the company, and each such proportion of capital stock to which each member has contributed and or entitled is his share. Okay, so this is what Lord Justice Lindley explained us about company in a very layman language. Okay, so now we will get into the definition of company as per the Companies Act. This is the legal provision. This is the definition given under the Act. The definition is given under Section 2, Clause 20 of Companies Act 2013. And what this definition is saying that a company is defined as an entity which is incorporated under this Act or any previous company law. Now, there are two things which it is saying. One is that the company has to be an incorporated company. That is, it has to be incorporated, or you can say it has to be registered under this act or any previous company law. Now, what do you mean by this act? This act means the 2013 Act. Okay, this act means the 2013 Act, and any previous company law, that is before 2013, any company which has been incorporated under the companies law which was relevant at that point of time. That means it may be a 1956 Act and so on. Okay, before this act there was Companies Act 1956, and after that in 2013, and after amending it it became Companies Act 2013. So the definition is clearly saying that a company which is incorporated under the Companies Act 2013, that is this act or any previous act, that is Companies Act 1956 and so on, will be considered as an company under the Companies Act. Okay, and such company will actually be an will be considered as an Indian because it is incorporated under the Indian Companies Act. So let's move ahead. Once we have understood the definition, we have understood that company is a separate legal entity. Company is a separate legal entity, which we said that it is an artificial legal person. Okay. Now, what do you mean by separate legal entity? Say there is a company A, and there are members, or you can call them as shareholders of such company. Now, when I say that company has a separate legal entity, it is an artificial legal person. That means it has a legal status apart from its members or distinct from its members and shareholders. So there is a line which has been drawn by the Companies Act that members and shareholders are not the same as the company. Members and shareholders are different persons, they have a different liability, and company has a different liability, different rights altogether. Okay. So company in itself has a legal status, so it can get into its own operations. It can hold property in its own name. It can sue anybody or be sued in its own name. Okay. And the members themselves do not form a company. Members are only members to the extent of their share capital in the company. Okay, they have limited liability in the company. Okay, so any acts of the company will not create a personal liability for the shareholders, nor the shareholders will create any personal liability for the company. Okay, so company does not act as an agent of the members. So the concept is that it has a separate legal identity distinct from its members, shareholders, and founders. Okay, so this is what is given over here, distinct from its members. Okay, distinct from its members. Company possesses an identity separate from its members and famously established in landmark case Salomon versus Salomon and Company. ये जो केस लॉ है ये बिल्कुल एक बेडरॉक है, एक बिल्कुल एक कॉर्नरस्टोन है पूरे कंपनी लॉ के लिए. ओके, एंड ये वाला केस लॉ तो आपको काफी अच्छे से आना चाहिए. अगर आप कंपनी लॉ के स्टूडेंट हो तो आपको ये केस लॉ का नाम तो पता होना चाहिए, लेकिन इसके अंदर जो कॉन्सेप्ट है, इसके अंदर जो फैक्ट्स ऑफ द केस है, ये भी आपको आना चाहिए. इसके लिए मैं एक सेपरेट वीडियो अपलोड करूंगा. मे बी आई विल स्टार्ट एंड सीरीज ऑन केस लॉज ऑल्सो, one video on case laws per week or something like that. And in that, the first video that I will be putting is for Solomon versus Solomon Company Limited. Now, the second point that I have put over here is that company will have independent operations, means it can own property, enter contracts, incur liabilities in its own name, independently of its shareholders. तो कंपनी का खुद के नाम पे प्रॉपर्टी हो सकता है, कंपनी के खुद के नाम पे एसेट हो सकता है. ये ऑलरेडी हमने डिस्कस कर लिया है. और ये भी मैंने डिस्कस किया था कि देर इज नो पर्सनल लाइबिलिटी ऑफ द मेंबर्स. ओके, मेंबर्स का लाइबिलिटी कहाँ तक होगा वो भी हम आगे डिस्कस करेंगे. लिमिटेड लाइबिलिटी जो एक कैरेक्टरिस्टिक है एक कंपनी के बारे में. ओके, तो ये पहला जो कैरेक्टरिस्टिक है सेपरेट लीगल एंटिटी, ये आपको समझ में आया है क्या? इसके कुछ केस लॉज जो है यहाँ पे मैं कवर कर रहा हूँ, यहाँ पे हाईलाइट किया हुआ है मैंने कि एक है सलोमन वर्सेस सलोमन कंपनी लिमिटेड. इसमें क्या था कि वंस ए कंपनी हैज बीन, इसमें ये कहा गया था कि वंस ए कंपनी हैज बीन वैलिडली कॉन्स्टिट्यूटेड अंडर द एक्ट, इट बिकम्स अ लीगल पर्सन distinct from its members, and it is immaterial. It is immaterial whether any member holds a large or small proportion of the shares. Okay, so this was the first case. Second case was Macquarie versus Northern Assurance Company. ये एक इंश्योरेंस का केस था जहाँ पे जो शेयर होल्डर है उसने खुद के नाम पे कंपनी के एसेट्स का इंश्योरेंस लिया था. ओके, तो इस केस में यही डिसाइड हुआ था कि ऐसा नहीं हो सकता, क्योंकि प्रॉपर्टी जो है वो एसेट जो है वो कंपनी खुद के नाम पे रख सकती है. कंपनी का जो प्रॉपर्टी है दैट इज नॉट द प्रॉपर्टी ऑफ द मेंबर्स, एंड ownership of shares do not equal to ownership of company's property. So this was the principle which came out of this case law. Okay. And last one more case is that so ली versus ली आर फार्मिंग लिमिटेड में क्या हुआ था कि जो ली करके एक पर्सन है जिसने ये कंपनी चालू की थी, वो उस कंपनी का फाउंडर था, वो उस कंपनी का मेजोरिटी शेयर होल्डर था, और वो उस कंपनी में एम्प्लॉय भी था एज अ चीफ पायलट। ओके। अब अनफॉर्चुनेटली उनके प्लेन का एक्सीडेंट हो जाता है, क्रैश हो जाता है, एंड ही डाइज इन दैट पर्टिकुलर एक्सीडेंट। उसकी जो वाइफ है, जो विडो है, she comes and asks for the compensation as it was her husband who died in the line of duty as an employee. Now the argument from the other side is that he was the controlling member of the company, he was the majority shareholder of the company, and hence the company need not give him any kind of compensation. But again, the court struck this down and this argument of the other party down, and ensured that the compensation is paid to the widow of Mr. Lee uh, because of the same concept of distinct legal personality. Okay, all three case laws are clear. I'm not going into the details over here. Again, you will be able to understand it in detail in my future videos. Okay, this was the first characteristics that we went through, that is separate legal identity. The second one is an interesting one, which is perpetual succession. Now, perpetual succession basically means that कंपनी, जैसे हम कहते हैं कंपनी अमर है, कंपनी क्या है, अमर है। इसका मतलब यह है कि कंपनी का डेथ नहीं हो सकता है, कंपनी खत्म नहीं हो सकती है जस्ट बिकॉज कोई मेंबर्स का डेथ हो गया, कोई मेंबर्स छोड़ के चला गया, या मेंबर्स ने ट्रांसफर कर दिया अपने शेयर्स को। ये सब रीजन की वजह से कंपनी का डेथ, या अब बोलो कंपनी टर्मिनेट नहीं हो सकती है। कंपनी का बर्थ जो है वो किस बेसिस पे हुआ? कंपनी का बर्थ जो हुआ वो हुआ इनकॉर्पोरेशन पे। वो किस पे हुआ? इनकॉर्पोरेशन पे हुआ अंडर दिस एक्ट ऑपरेशन ऑफ विच इज एन ऑपरेशन ऑफ लॉ। सो कंपनी को हम खत्म भी तभी कर सकते हैं, कंपनी कैन बी terminated only and only when it goes through the process of either the dissolution or winding up procedure under this act. Again, it is an operation of law. Okay. So even though all the members of the company die or they leave the company, still the company will still remain, company will still exist. This is the concept of perpetual succession. The same thing has been given over here in this notes. That is, it continues despite the death, insolvency, or insanity of its members. Shares are transferred to legal representatives or nominees, ensuring uninterrupted business operations. Now, you have to quote, whenever this question comes, you have to quote LCB Govar over here. And this quote, what is his quote? His quote is members may come and go. Members may come and go, but the company will always continue to exist. The company came into existence by operation of law and can be terminated only by operation of law, that is resolution or winding up. Now, the next simple point is limited liability. Limited liability means what? Any shareholder, any member, okay, will have limited liability, will have limited liability to the extent of the unpaid value of his shares. That means if a member has a share of face value 10 rupees, okay, of which 5 rupees is paid, that means his liability will be rupees 5, which is unpaid. Okay, so this basically is the concept of limited liability. So limited liability will be the liability of the company's members is limited to the unpaid amount of their shares or the guarantee amount. Okay, or the guarantee amount means what? Now this we are speaking from the concept of company limited by shares. Okay, going forward, we will also discuss the types of companies. In that, we will know that one is company limited by shares, and other is company limited by guarantee. Now, this is also type of company, and in this, the members will give. Okay, guarantee an amount in the memorandum of association, and they will say in case tomorrow the company goes into liquidation or finds any problem, then they will contribute their amount to the extent of the guarantee that they have given in the memorandum of association. Liability of such members will be limited to that extent only. The guarantee that has been provided by them in the memorandum of association. Okay, I hope this point is also clear. Hmm? First is unpaid value. First is unpaid value of the shares held by them, and in case of guarantee, it is to the extent of guarantee given or undertaken in the memorandum of association. Okay. Now, why is this important? This is very, very important because this shields the members, the investors, from any unlimited liability or extra liability. So their personal assets are not going to be affected because of companies' debts and obligations. What would this do in turn is that इससे क्या होगा कि जो भी मेंबर है, जो भी पर्सन है जिसको इन्वेस्ट करना है कंपनी में, उसे पता है कि मैं अगर इस कंपनी में 10,000 रुपया डाल रहा हूँ तो 10,000 रुपया तक का ही मेरा रिस्क है। ठीक है, उसे उसका फाइनेंशियल रिस्क जो है वो लिमिटेड है एंड क्लियर है। तो उसके जो पर्सनल प्रॉपर्टी के ऊपर कोई प्रॉब्लम नहीं होगा। तो इससे क्या हो जाएगा, उसको अपना जब रिस्क पता है तो वो इन्वेस्ट करने के लिए ज्यादा एनकरेज होगा। सो this would increase or this would encourage investment and capital formation. So the concept of limited liability समझ में आ गया हमको यहाँ पे। नेक्स्ट क्या है, नेक्स्ट कॉन्सेप्ट है कॉमन सील का। कॉमन सील जो है अभी ये मैंडेटरी नहीं है, नाउ इट इज ऑप्शनल एंड नॉट मैंडेटरी इन टूडेज टाइम्स। ओके, पहले ऐसा हुआ करता था कि कॉमन सील हुआ करता था कंपनी का, जो भी डॉक्यूमेंट्स कंपनी का है उसे ऑथराइज करने के लिए, उसे ऑथेंटिकेट करने के लिए उसके ऊपर कॉमन सील का होना जरूरी होता था। आज की तारीख में इसे मैंडेटरी नहीं कहा गया है, इसे ऑप्शनल कर दिया गया है। इसका मतलब यह है कि कॉमन सील का आज की तारीख में डॉक्यूमेंट्स में जरूरत नहीं है। इट इज ओनली दी सिग्नेटरीज हैव टू साइन ऑन दी डॉक्यूमेंट्स एंड दैट इज मोर देन इनफ टुडे। नेक्स्ट एक बहुत ही इंपॉर्टेंट पॉइंट यहाँ पे कंपनी के केस में ये आता है कि ट्रांसफरेबिलिटी ऑफ शेयर्स। ये काफी हद तक बाकी सारे टाइप्स ऑफ एंटिटी से इसे अलग बनाता है। जैसे कि अब मैं पहले ये इलस्ट्रेशन समझते हैं हम लोग। अगर ए कंपनी है, ए कंपनी में मिस्टर अभिषेक के पास 10,000 शेयर्स है। ठीक है, नाउ मिस्टर अभिषेक कैन ट्रांसफर दिस शेयर्स मिस्टर महेश and Mr. Suresh, okay, in whatever proportion he wants, say 5,000, 5,000. He can transfer it at 3,000, 7,000, or he can even transfer it, say 2,000, 3,000, and keep the balance 5,000 with himself. Okay, so इससे दो चीजें हमें समझ में आती है कि मिस्टर अभिषेक, who is the shareholder or member of A company limited and holds 1,000 shares, can freely can freely transfer his shares to whomsoever he wants, okay, in whatever proportion he wants, okay। तो इसका मतलब क्या है, पहला चीज ये होता है कि ये जो शेयर्स है, ये क्या है, ये शेयर्स जो है ये है मूवेबल प्रॉपर्टी। ये क्या है, मूवेबल प्रॉपर्टी है। तो जब भी अभिषेक ने महेश को 5,000 शेयर्स ट्रांसफर किए, तो महेश के पास ये जो शेयर्स आए हैं, ये क्या हो गया, ओनरशिप भी उसके पास ट्रांसफर हो चुका है। इसीलिए हम इसे कहते हैं मूवेबल प्रॉपर्टी। ओके, एंड क्योंकि ये आप जितना चाहिए जिसको चाहिए आप कर सकते हो, इसीलिए हम क्या कहते हैं, इसे फ्रीली ट्रांसफरेबल। ओके, notes over here. So shares are generally considered as movable property, freely transferable. However, private companies may impose specific restrictions. Private companies may impose specific restrictions on share transfers through their articles of association. अभी articles of association सब क्या है, ये हम लोग आगे पढ़ेंगे, इतना टेंशन मत लो। अभी अलग से इसके ऊपर डिस्कशन होगा, एक अलग टॉपिक है ये आर्टिकल्स ऑफ एसोसिएशन, मेमोरेंडम ऑफ एसोसिएशन, ये सब। ठीक है, अभी के लिए खाली इतना समझो कि अगर एक प्राइवेट कंपनी है तो प्राइवेट कंपनी कुछ रिस्ट्रिक्शंस डाल सकती है अपने मेंबर्स पे ऑन ट्रांसफरेबिलिटी ऑफ, बट एक पब्लिक कंपनी में तो देयर इज नो रिस्ट्रिक्शंस। इट इज इट इज फ्रीली ट्रांसफरेबल। ओके, ये फीचर से क्या होता है, ये वाला जो कैरेक्टरिस्टिक है, इससे क्या होता है कि कैपिटल मोबिलिटी बढ़ जाता है, लिक्विडिटी बढ़ जाता है, इन्वेस्टर्स को क्या मिल जाता है, एग्जिट ऑप्शंस मिल जाता है, ओवरऑल लिक्विडिटी जो है शेयर्स का वो भी बढ़ जाता है। अब जो लास्ट पॉइंट जो हम लोग डिस्कस करेंगे वो आर्टिफिशियल पर्सन एंड लीगल कैपेसिटी के बारे में। इसके बारे में स्टार्टिंग में हमने ऑलरेडी डिस्कस कर लिया। ये कैरेक्टरिस्टिक ऑफ ए कंपनी की कंपनी जो है वो क्या है, आर्टिफिशियल पर्सन है, इट इज ब्रॉट इनटू एग्जिस्टेंस बाय लॉ, एंडोर्ड विथ लीगल राइट्स एंड ड्यूटीज, इट इज नॉट ए ह्यूमन बीइंग बट एक्ट्स थ्रू ह्यूमन बीइंग्स। तो एक कंपनी के पास राइट्स भी होते हैं और कुछ ड्यूटीज भी होते हैं। तो क्या सारे राइट्स होते हैं? क्या एक कंपनी को हम कह सकते हैं कि वो कंपनी सिटीजन बन चुकी है इंडिया की? डज दिस मीन दैट a company incorporated under the Indian law is also a citizen of India? After understanding all the characteristics of the company, do you feel that the company is and being a legal person, it also becomes a citizen of India? So the answer to it is no, it is not considered as a citizen of India. Why? Because it is not a natural person, and secondly, it does not have all the fundamental rights that are given to a natural person, like right to life, right to liberty, right to freedom of speech, etc., etc. Okay, so there was an important case law on this, that is State Trading Corporation of India versus Commercial Tax Officer, in which it was held that a company, though incorporated in India, is not a citizen under the Indian Constitution. Okay, and it further said that it cannot claim for fundamental rights that are available only to citizens, such as Article 19, protection of certain rights like freedom of speech, right of life, right of personal liberty, etc., etc. So, in conclusion, we can say the company is a juristic person and not a natural person. It does not have citizenship, but it has a nationality. It has a domicile. It is an Indian company. Okay, it is an Indian company if it is incorporated under the Companies Act in India. Okay, it enjoys certain constitutional and legal rights, but not rights exclusive to the Indian citizens. Okay, I hope you have understood the definition of company. I hope you have understood the characteristics of company. This is summary in which I have laid down all the characteristics once again. Just go through it. I will be attaching a link in the description on the notes, the whole notes that I have used over here. I will be attaching this lecture notes in the description. You can download it, you can use it, you can revise through it. I hope this video was useful for you. And if it was useful, do subscribe to this channel, like this video. It keeps me motivated to bring many more videos like this. So till the next video, that's it from me. Bye.